Good morning, everyone, and welcome to another ambush stream of legal news. While this subject isn't one that I've covered all that much or worried a whole heck of a lot about since maybe the Lords of the Night days talking about politics in general, it was something I was curious to see the outcome of. And so consequently, since I did enjoy reading through the majority opinion of the affirmative action case yesterday, I thought, what the heck? I'll read through the decision on student debt forgiveness. And not just Joe Biden's, but several other politicians' attempts or wish over the last several cycles of trying to make student debt forgiveness a campaign promise they could fulfill. Well, now the court has weighed in on that idea, at least in the way in which Joe Biden attempted to go about it. And so we'll read about that momentarily. But before that, who's joining me on this beautiful Friday morning ahead of a holiday weekend, for those of you that have the holiday? Shady Grin, good morning. John Miller, Tony Giff, Olga Karakati. Who else is here? Ostsan, Tall Person, Bridget, Attack Alpaca, No Name, Renovatio. Good morning. And anybody that I miss who's just coming in, or anybody who's lurking, or anybody in the future, good morning. Oh, Mike Savage, Blarg. So yes, let's read the decision from the Supreme Court about student debt forgiveness. Now, this was the idea, I believe, to try to just basically wipe away between $10,000 to $20,000 in federal student loan debt as held by, I suppose, anybody who had debt at the time the thing passed. That would do nothing for anybody who had debt the day before the thing passed or had paid off all their debts as a responsible individual prior to that. I think I last really focused on this, like I said, back in the Lords of the Night era, where we were talking about the kind of campaign promises that hasn't originated with, but was probably made most famous by Bernie Sanders in his campaign in 2016, and then again in 2020, and was also taken up at some point by Elizabeth Warren, I think, tried to copy Bernie's strategy and trying to offer that. And then, of course, Joe Biden took it up, and here we are. So let's go through the majority opinion by the Supreme Court. And when I first saw this, I thought this was a incorrect posting, because I saw Department of Education v. Brown, and I'm like, Brown v. Education? No, this is not Brown v. Board of Education. It was the other way around. So anyway, certiorari before judgment to the United States Court of Appeals for the Fifth Circuit. To alleviate hardship expected to be caused by the impending resumption of federal student loan repayments that had been suspended during the multi-year coronavirus pandemic, Secretary of Education Miguel Cardona announced a substantial student loan debt forgiveness plan, otherwise known as the plan. The plan discharges $10,000 to $20,000 of an eligible borrower's debt, depending on criteria such as the borrower's income and the type of loan held. The Secretary invoked the Higher Education Relief Opportunities for Students Act of 2003, or the HEROES Act, oh God, which authorizes the Secretary to, quote, waive or modify any provision, unquote, applicable to federal, quote, student financial assistance, unquote, programs, quote, as may be necessary to ensure that recipients of student financial assistance are no worse off financially in relation to that financial assistance because of a national emergency or disaster. The HEROES Act also exempts rules promulgated pursuant to it from the otherwise applicable negotiated rulemaking and notice and comment processes. I can't believe I said all that without stumbling over it. That's a lot of words. Before the plan took effect, various plaintiffs, including respondents here, sued to enjoin it. Respondents Myra Brown and Alexander Taylor are two borrowers who do not qualify for the maximum relief available under the plan. Their one-count complaint alleges that the Secretary was required to follow notice and comment and negotiated rulemaking procedures in promulgating the plan, which all agree he did not do. Brown and Taylor argue that the HEROES Act procedural exemptions apply only when the rule promulgated is substantively, Irate Bear, authorized by the Act. And because the HEROES Act does not authorize the plan, they argue, the Secretary was required to follow negotiated rulemaking and notice and comment. The district court rejected their argument regarding the scope of the HEROES Act procedural exemptions, but nevertheless vacated the plan as substantively unauthorized. I can't help myself. I keep wanting to say irate bear every time I say that word. Substantively. This court granted certiorari before judgment to consider this case alongside Biden v. Nebraska, which presents a similar challenge to the plan. Held. Because respondents failed to establish that any injury they suffer from not having their loans forgiven is fairly traceable to the plan, they lack Article 3 standing, so the court has no jurisdiction to address their procedural claim. Pages 16 through 15. A. This case begins and ends with standing, unquote. Carney v. Adams, 592 U.S. blankety blank. Okay. The court's authority under the Constitution is limited to resolving cases or controversies. Article 3, subsection 2. The court's jurisprudence has, quote, established the irreducible I did well before, I'm stumbling now. Established that the irreducible constitutional minimum of standing contains 3 elements that a plaintiff must plead and ultimately prove. Those elements are 1, a concrete and particularized injury that is 2, fairly traceable to the challenged action of the defendant, and 3, likely to be redressed by a favorable decision. But where, as here, the plaintiff alleges that she has been deprived of a procedural right to protect her concrete interest, she need not show that observing the contested procedure would necessarily lead to a different substantive result. As articulated in this court, respondents' claim and theory of standing are twofold. First, because the HEROES Act does not substantively authorize the plan, the Secretary was obligated to follow typical negotiated rulemaking and notice and comment requirements. Second, if the Secretary had observed those procedures, respondents might have used those opportunities to convince him not only that proceeding under the HEROES Act is unlawful, but also that he should instead adopt a different loan forgiveness program under the Higher Education Act of 1965, and to make that program more generous to respondents than the plan. Respondents assert there is at least, okay, sorry, my brain went sideways for a second there. Respondents assert there is at least a chance that this series of events will come to pass now if this court vacates the plan. C. Respondents' standing claim most clearly fails on traceability. They cannot show that their purported injury of not receiving loan relief under the HEA is fairly traceable to the department's, allegedly unlawful, decision to grant loan relief under the HEROES Act. Significantly, respondents are not claiming that they are injured by not being sufficiently included among the plan's beneficiaries. They think the plan is substantively unlawful and instead seek debt forgiveness under the HEA. But a decision regarding the lawfulness of the plan does not directly affect respondents' ability to obtain loan relief under the HEA. The department's authority to grant loan relief under the HEA, upon which the court does not pass, is not affected by whether the plan is lawful or unlawful. Any connection between loan forgiveness under the 2 statutes is speculative. While it is true that the court's procedural standing case law tolerates uncertainty over whether observing certain procedures would have led to or caused a different substantive outcome, see Lujan 504 U.S. at 572 North 7, the causal uncertainty here is not so limited. Instead, the uncertainty concerns whether the substantive decisions the department has made regarding the plan under the HEROES Act have a causal relationship with the other substantive decisions respondents want to... Yesterday it seemed so clear and understandable to me, and now it's just like, you want to talk about the most dense and obscure legalese. I apologize. I thought this would be a bit more straightforward. Okay, let me start back a little bit. Instead, the uncertainty concerns whether the substantive decisions the department has made regarding the plan under the HEROES Act have a causal relationship with other substantive decisions respondents want the department to make under the HEA. There is no precedent for tolerating this sort of causal uncertainty. Respondents cannot show that the denial of HEA loan relief, their ostensible injury, quote, fairly can be traced to, unquote, the department's decision to grant loan relief in the plan. There is little reason to think that the department's discretionary decision to pursue one mechanism of loan relief under the HEROES Act has anything to do with its discretionary decision to pursue or not pursue action under the HEA. Quote, the line of causation between, unquote, the department's promulgation of the plan and respondents' lack of benefits under the HEA is attenuated at best. Allen v. Wright, 468 U.S. 757, and all too dependent on conjecture. Okay, 2, respondents' attempts to use the plan Pardon me. Respondents' attempt to tie the plan to potential HEA relief are unavailing. Although the department has occasionally referred to one-time student loan relief in publicizing the plan itself contains no such reference. And any incidental effect of the plan on the likelihood that the department will undertake a separate loan forgiveness program under a different statute is too weak and speculative to show that the absence of the HEA-based loan forgiveness is fairly traceable to the plan. Okay, to the extent the department has determined that the plan crowds out other efforts to forgive student loans, that determination is a discretionary one that respondents may petition the department to reconsider. Finally, respondents cannot demonstrate causation on the theory that the department's failure to observe the requisite procedural rules cost them a chance to obtain debt forgiveness. They do not want debt forgiveness under the HEROES Act, and nothing the department has done deprives them of the chance to seek debt forgiveness under the HEA. Respondents cannot meaningfully connect the absence of loan relief under the HEA to the adoption of the plan, so they have failed to show that their injury is fairly traceable to the plan. Vacated and remanded. Okay. Okay, so that was the first thing about the undercourt, the lesser court. Okay, opinion of the court. Now we get to the petition. Petition. The opinion. Legalese makes my brain go blah, blah, blah. All right. Oh, wait, somebody's saying something about me in the chat. What is being said about me in the chat? Some Nemnul Nation said something about me. What? Uh-oh. Uh-oh, what's this? Now I understand what someone means when they say, I'd listen to that guy read the phone book. Oh, you gosh. I think I'm blushing. All right, let's get down to the next part of this. Department of Education et al. Petitioners versus Myra Brown et al. On writ of certiorari of the United States Court of Appeals of the Fifth Circuit. Justice Alito delivered the opinion of the court. In August 2022, the Secretary of Education announced a large-scale student debt forgiveness plan. He pledged to discharge hundreds of billions of dollars in student loan debt owed by millions of borrowers. According to the Secretary, the discharge was necessary to alleviate hardship caused by the impending resumption of loan repayments, which had been suspended during the multi-year coronavirus pandemic, and he therefore invoked authority that he claimed he enjoyed under the Higher Education Relief Opportunities for Students Act of 2003, the HEROES Act. The following month, the Secretary directed that specific actions be taken to implement the loan forgiveness plan. The amount of relief available to a borrower under the plan depends on various criteria, including the borrower's income and the type of loan the borrower holds. Before the plan took effect, however, this is just a repeat of the previous, isn't it? Let's see. Let me check something real quick just to make sure I'm not completely off base. I mean, it could be just my lack of legalese training. But was that the decision that, because purportedly, as I understand it, the student loan forgiveness plan was all struck down, basically like today. Was this the opinion that did it? I don't know. Let's see here. 1 second. Come on. Opinions of the court. Yes. All right. Biden, this is the one I read the wrong one. Well, that gives us a little bit of an insight into the part of the problem, part of the equation. Let's get into the actual thing regarding Joe Biden's attempt. Oh man, I apologize, guys. I was under a misapprehension. So let's take a look at the part of the decisions dealing with Biden, President of the United States et al. V. Nebraska. This is it. So false start, but hey, I got my legalese tongue tying out of the way, hopefully. All right, here we go. Title VI of the Higher Education Act of 1965 governs federal financial aid mechanisms, including student loans. The act authorizes the Secretary of Education to cancel or reduce loans in certain limited circumstances. The Secretary may cancel a set amount of loans held by some public servants. He may also forgive the loans of borrowers who have died or become, quote, permanently and totally disabled, unquote, borrowers who are bankrupt, and borrowers whose schools falsely certify them, close down, or fail to pay lenders. The issue presented in this case is whether the Secretary has authority under the Higher Education Relief Opportunities for Students Act of 2003, HEROES Act, to depart from the existing provisions of that Education Act and establish a student loan forgiveness program that will cancel about $430 billion in debt principal and affect nearly all borrowers. Under the HEROES Act, the Secretary, quote, may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under Title IV, of the Education Act as the Secretary deems necessary in connection with a war or other military operation or national emergency, unquote. As relevant here, the Secretary may issue such waivers or modification only, quote, as may be necessary to ensure, unquote, that, quote, recipients of student financial assistance under Title IV of the Education Act affected by a national emergency are not placed in a worse position financially in relation to that financial assistance because of the national emergency. In 2022, as the COVID-19 pandemic came to its end, the Secretary invoked the HEROES Act to issue, quote, waivers and modifications, unquote, reducing or eliminating the federal student debt of most borrowers. Borrowers with eligible federal student loans who had an income below $125,000 in either 2020 or 2021 qualified for loan balance discharge of up to $10,000. Those who previously received Pell Grants, a specific type of federal student loan based on financial need, qualified for a discharge of up to $20,000. 6 states challenged the plan as exceeding the Secretary's statutory authority. The Eighth Circuit issued a nationwide preliminary injunction, and this court granted certiorari before judgment. Held, number 1, at least Missouri has standing to challenge the Secretary's program. Article 3 requires a plaintiff to have suffered an injury in fact, a concrete and imminent harm to a legally protected interest like property or money that is fairly traceable to the challenged conduct and likely to be redressed by the lawsuit. This is where that first one comes in. It kind of leads into the other. Here, as the government concedes, the Secretary's plan would cost Mohella. What is Mohella? I'm assuming that's a Missouri thing. A nonprofit government corporation created by Missouri to participate in the student loan market, an estimated $44 million a year in fees. Mohella is, by law and function, an instrumentality of Missouri. Labeled an instrumentality by the state, it was created by the state, is supervised by the state, and serves a public function. The harm to Mohella in the performance of its public function is necessarily a direct injury to Missouri itself. The court reached a similar conclusion 70 years ago in Arkansas v. Texas, 346 U.S. 368. The Secretary emphasizes that, as a public corporation, Mohella has a legal personality separate from the state, but such an instrumentality, created and supervised by the state to serve a public function, remains, quote, for many purposes at least, part of the government itself, unquote. LeBron v. National Railroad Passenger Corporation, 513 U.S. 374 397. The Secretary also contends that because Mohella can sue on its own behalf, it, not Missouri, must be the one to sue. But where a state has been harmed in carrying out its responsibilities, the fact that it chose to exercise its authority through a public corporation it created and controls does not bar the state from suing to remedy that harm itself. See Arkansas 346 U.S. 368. While Article 3 satisfied, with Article 3 satisfied, the court need not consider the state's other standing arguments. Number 2, the HEROES Act allows the Secretary to waive or modify existing statutory or regulatory provisions applicable to financial assistance programs under the Education Act, but does not allow the Secretary to rewrite that statute to the extent of canceling $430 billion of student loan principal. A, the text of the HEROES Act does not authorize the Secretary's loan forgiveness program. The Secretary's power under the Act to modify does not permit, quote, basic and fundamental changes in the scheme, unquote, designed by Congress. MCI Telecommunications Corp. v. American Telephone and Telegraph Company, 512 U.S. 218 225. Instead, modify, quote unquote, carries, quote, a connotation of increment or limitation, unquote, and must be read to mean, quote, to change moderately or in minor fashion, unquote. That is how the word is ordinarily used and defined, and the legal definition is no different. Oh boy, real quick, thank you big time. Mohella is a loan servicer for the Department of Education. They also run public service loan forgiveness. Gotcha. Yeah, I didn't know what that was, but apparently the argument was Mohella could not make this claim because they did not actually represent the state, that they were a separate corporation. But the court obviously argues that it is an entity entirely controlled by, created by, and services the state. Therefore, it is effectively a proxy for the state in all intents and purposes. Thank you, big time. Yeah, I didn't know Mohel. I assumed the M stood for Missouri in that context clues and all that. But hey, you learn something new every day. The authority to, quote, modify statutes and regulations allows the Secretary to make modest adjustments and additions to existing provisions, not transform them. Prior to the COVID-19 pandemic, quote unquote, modifications issued under the Act were minor and had limited effect. But the quote unquote modifications challenged here create a novel and fundamentally different loan forgiveness program. While Congress specified in the Education Act a few narrowly delineated situations that could qualify a borrower for loan discharge, the Secretary has extended such discharge to nearly every borrower in the country. It is, quote, highly unlikely that Congress, unquote, authorize such a sweeping loan cancellation program, quote, through such a subtle device as permission to modify, unquote. Yeah, so the argument was the Secretary was far, far overreaching his bounds in what the law allowed in just making a blanket forgiveness of debt amounting to $430 billion for everybody. Yeah, so modification does not mean radical transformation. It's legalese, but it's important. The Secretary responds that the Act authorizes him to waive, unquote, legal provisions as well as modify them, and that this additional term, quote, grants broader authority, unquote, than would modify alone. But the Secretary's invocation of the waiver power here does not remotely resemble how it has been used in prior occasions, where it was simply used to nullify particular legal requirements. Oh, is this legal precedent? Is this the definition of words and legal precedent? Are they going to argue against legal precedent? Anyway, the Secretary next argues that the power to, quote, waive or modify, unquote, is greater than the sum of its parts. Because waiver allows the Secretary, quote, to eliminate legal obligations in their entirety, unquote, the combination of, quote, waive or modify, unquote, must allow him, quote, to reduce them to any extent short of waiver, even if the power to modify ordinarily does not stretch that far. But the challenged loan forgiveness program goes beyond even that. In essence, the Secretary has drafted a new section of the Education Act from scratch by, quote, waiving, unquote, provisions root and branch, and then filling the empty space with radically new text. The Secretary also cites a procedural provision in the HEROES Act directing the Secretary to publish a notice in the Federal Register, quote, including the terms and conditions to be applied in lieu of such statutory and regulatory provisions, unquote, as the Secretary has waived or modified. In the government's view, that language authorizes both, quote, waiving and then putting the Secretary's own requirements in a sort of red penciling of the existing law. But rather than implicitly granting the Secretary authority to draft new substantive statutory provisions at will, number two simply imposes the obligation to report any waivers and modifications he has made. The Secretary's ability to add new terms, quote, in lieu of, unquote, the old, is limited to his authority to, quote, modify existing law. As with any other modification issued under the Act, no new term or condition reported pursuant to 1098BB-B2 may distort the fundamental nature of the provision it alters. In sum, the Secretary's comprehensive debt cancellation plan is not a waiver because it augments and expands existing provisions dramatically. It is not a modification because it constitutes, quote, effectively the introduction of a whole new regime, unquote. And it cannot be some combination of the two, because when the Secretary seeks to add to existing law, the fact that he has waived certain provisions does not give him a free pass to avoid the limits inherent in the power to modify. However broad the meaning of waive or modify, that language cannot authorize the kind of exhaustive rewriting of the statute that has taken place here. Dang! That kind of shuts the door, don't it? B, the Secretary also appeals to congressional purpose, arguing that Congress intended, quote, to grant substantial discretion to the Secretary to respond to unforeseen emergencies, unquote. On this view, the unprecedented nature of the Secretary's debt cancellation plan is justified by the pandemic's unparalleled scope. But the question here is not whether something should be done, it is who has the authority to do it. As in the court's recent decision in West Virginia versus EPA, given the, quote, history and the breadth of the authority, unquote, asserted by the executive and the, quote, economic and political significance of that assertion, unquote, the court has, quote, reason to hesitate before concluding that Congress meant to confer such authority, unquote. This case implicates many of the factors present in past cases raising similar separation of powers concerns. The Secretary has never previously claimed powers of this magnitude under the HEROES Act. Quote, no regulation premised on the HEROES Act has even begun to approach the size or scope of the Secretary's programs. Alabama Association of Realtors versus Department of Health and Human Services, 594 U.S. blank per curiam. The, quote, economic and political significance of the Secretary's action is staggering, and the Secretary's assertion of administrative authority has, quote, conveniently enabled him to enact a program, unquote, that Congress has chosen not to enact itself. And this is always the thing. Trying to do an end run around the legislative branch, whether in its executive action or trying to empower a secretary with abilities that they don't actually possess, trying to get around congressional action for those things that should be legislated in the Congress. It's trying to do an end run around the process. And no, the answer is no. You don't get to. This is like the epitome of rules lawyering for those of you that are tabletop role players out there. Except that this is rules lawyering on the highest degree with federal law, and I'm glad the court stopped them there because again, you start letting things like this pass, somebody's going to repeat it and repeat it. You start granting powers to appointments and departments in the government that don't have that power, they're going to use it. If they can get away with it once, they will get away with it again. The Secretary argues that the principles explained in West Virginia and its predecessors should not apply to cases involving government benefits. But major questions cases, is that a legal term? I don't know. But major questions cases, quote, have arisen from all corners of the administrative state, unquote. And this is not the first such case to arise in the context of government benefits. All this leads the court to conclude that the basic and consequential trade-offs inherent to a mass debt cancellation program, quote, are ones that Congress would likely have intended for itself, unquote. In such circumstances, the court has required the Secretary to, quote, point to clear congressional authorization, unquote, to justify the challenged program. And as explained, the HEROES Act provides no authorization for the Secretary's plans when examined using the ordinary tools of statutory interpretation, let alone, quote, clear congressional authorization, unquote, for such a program. Reversed and remanded. And let's see. I'm going to take a look. Do we have the dissents here? Justice Roberts, to the opinion. Yep. Let's see if I want to find the dissent. I'm curious to hear what our given yesterday's drama with Clarence Thomas, I'm curious to find out what our newest Supreme Court justice has to say on the subject. Is that still... Here, let's keep going here. Sorry, let me just... Don't I get a page down thing? I guess not. Okay, well. Let's see. Where is... Yep. Hold on. Let's see if I can find the dissent, if I haven't already skipped over it accidentally. Because I'd be curious to read it. Okay, here we go. Joseph R. Biden, Justice Barrett concurring. No, we want to get to... I don't want the concurrence. I want the dissent. And not that cool horror movie from many years ago. Justice Kagan. No, I want to hear our latest and greatest. No. Sorry, guys. I apologize for the relative dead air here, but since I don't apparently have a, or did she submit? I guess the question is, did she submit a dissent? Maybe she didn't. Okay. Oh, no, she didn't submit a written dissent. Let's see what Kagan had to say then, as the apparently lone authored dissenter in this. Okay. All right. In every respect, the court today exceeds its proper limited role in our nation's governance. Its proper limited role in our nation's governance. The executive branch seeks to supersede the congressional branch, and the court is exceeding its proper limited role? Okay. Some 20 years ago, Congress enacted legislation called the HEROES Act, authorizing the Secretary of Education to provide relief to student loan borrowers when a national emergency struck. The Secretary's authority was bounded. He could only do what was, quote, necessary, unquote, to alleviate the emergency impact on affected borrowers' ability to repay their student loans. But within that bounded area, Congress gave discretion to the Secretary. Hold on a second. Wasn't student loan forgiveness something that was being promised and talked about politically before the pandemic? I mean, but before there was a pandemic, wasn't this something that was being dangled out there as a possible campaign promise? Am I just blanking on that? So it seems more like the pandemic was used as an excuse to fulfill a campaign promise. Or is that just me? Anyway, Congress gave discretion to the Secretary. He could, quote, waive or modify any statutory or regulatory provision, unquote, applying to federal student loan programs, including provisions relating to loan repayment and forgiveness. And in so doing, he could replace the old provisions with new, quote, terms and conditions, unquote. Replace? I mean, outright replace? It doesn't say replace. It says waive or modify. You're adding text to what Congress authorized that wasn't there, which is kind of what the Secretary was doing in his argument. Okay, the Secretary, that is, could give the relief that was needed in the form he deemed most appropriate to counteract the effect of a national emergency on borrowers' capacity to repay. That may have been a good idea, or it may have been a bad idea. Either way, it was what Congress said. Where did they say replace? I mean, we're down to legalese here, right? This is where the devil's in the details. Where did they say that he could outright wholesale replace provisions? It says waive or modify, not replace. I think you failed at the starting line here. And I'm not even a legal expert. When COVID hit, two secretaries serving two different presidents decided to use their HEROES Act authority. Okay, in what way? The first suspended loan repayments and interest accrual for all federally held student loans. Yeah, suspended means putting a pause. That's not outright changing it, right? It's waiving a deadline, which is within the language of what Congress passed. Okay. The second continued that policy for a time and then replaced it with the loan forgiveness plan at issue here. Again, replace. Okay, a waiver, suspending the loan deadlines and suspending the repayments is not a replacement of the provisions. It is a temporary waiver and in some way, shape, or form then, of course, a modification. It does not eliminate or entirely replace the language of the law. The word replaced here to me, and this is just my English major talking, is the key problem with the dissent's argument here. We're not talking about Congress authorized replacement. The two words are waive and modify, not rewrite, not replace, not redraft. The second continued that policy for a time and then replaced it with the loan forgiveness program at issue here, granting most low and middle income borrowers up to $10,000 in student relief. Both relied on the HEROES Act language cited above. Yes, but in one instance, the action taken was a temporary modification to the deadlines on repaying the debt. It was not eliminating language. In the second instance, it's completely rewriting the law. Any other legal experts out there, or any other, anybody who understands this stuff better than I do, tell me if I'm completely off base when I keep coming across this word replace. That is not in quotations, mind you. She's not quoting the HEROES Act. She's using the word replaced outside of what's in the act. In establishing the loan forgiveness plan, the current secretary scratched the pre-existing conditions for loan discharged and specified different conditions opening loan forgiveness to more borrowers. So he waived and modified statutory and regulatory provisions and applied other, quote, terms and conditions in their stead. I don't think that's how it works. And it seems like the other justices didn't either. That may have been a good idea, or it may have been a bad idea. Either way, the secretary did only what Congress had told him he could. Where is the word replace? Where is the word rewrite? I'm at a loss here. I'm at a loss. Unless this is just a dissent for the sake of dissenting. The court's first overreach on this case is deciding it at all. Under Article 3 of the Constitution, a plaintiff must have standing to challenge a government action, and that requires a personal stake, an injury in fact. We do not allow plaintiffs to bring suit just because they oppose a policy. Neither do we allow plaintiffs to rely on injuries suffered by others. Those rules may sound technical, but they enforce, quote, fundamental limits on federal judicial power, unquote. They keep courts acting like courts, or stated the other way around, they prevent courts from acting like this court does today. The plaintiffs in this case are 6 states that have no personal stake in the Secretary's loan forgiveness plan. Okay, how does Mohela not qualify? They are classic ideological plaintiffs. They think the plan is a very bad idea, but they are no worse off because the Secretary differs. Well, what about the Mohela argument about the amount of money that they would then lose and the state would then suffer from their coffers as a result of it? Does that not become damages? Okay. In giving those states a forum in adjudicating their complaint, the court forgets its proper role. The court acts as though it is an arbiter of political and policy disputes rather than of cases and controversies. Okay. And the court's role confusion persists when it takes up the merits. For years, this court has insisted the way to keep judges' policy views and preferences out of judicial decision-making is to hew it to a statute's text. The HEROES Act's text settles the legality of the Secretary's loan forgiveness plan. You inserted the word replace. You didn't quote the word replace. You didn't quote rewrite. You didn't quote, completely redraft. None of that. Waive and modify. And the example you gave, suspended the loan payments. Now that was within the boundaries, waiving for a time, but it wasn't like if the first Secretary of State in this instance under Trump had said, we're just not going to charge anybody loan fees anymore. I mean, that's no less an extreme alteration of the law than what is being suggested here. Would that have been okay? Just say, no, we're just not going to collect loan payments ever. Any loan payments that come due during the course of the pandemic are hereby just, we're going to ignore them completely. We won't even come chasing you for them. In fact, if your loan period ends during the pandemic, you're free. What if you said that? Would that have been fine? I mean, it's no more egregious or vulgar a change of the established law under Congress than what this is. I wonder if she would have agreed to that. The statute provides the Secretary with broad authority to give emergency relief to student loan borrowers, including by altering usual discharge rules. What the Secretary did fits comfortably within that delegation, but the court forbids him to proceed. As in other recent cases, the rules of the game change when Congress enacts broad delegations allowing agencies to take substantial regulatory measures. Then, as in this case, the court reads statutes unnaturally, seeking to cabin their evident scope, and the court applies heightened specificity requirements, thwarting Congress's efforts to ensure adequate responses to unforeseen events. So from the language in the law, you think Congress's intent was to give the Secretary power to completely rewrite the law outside of congressional oversight when it said waive or modify. You think Congress was just like, okay, we're going to abdicate the legislative branch to the secretary under any circumstance he deems fit to rewrite federal law on the fly. That's what you think waive and modify? Is that how we should be looking at our different departments now? I don't know. I think the implications in the dissent here are more worrying to me than the decision to accept a state agency as a plaintiff. The result here is that the court substitutes itself for Congress. The court substitutes itself for Congress. The secretary substituted himself for Congress. What? In your own example, you went from suspending the loan payment schedule for the sake of the emergency to outright doing away with $430 billion worth of debt under federal loans. The court substitutes itself for Congress. Okay. The result here is that the court substitutes itself for Congress and the executive branch in making national policy about student loan forgiveness. What? Congress authorized the forgiveness plan among any other act. When? When did Congress authorize $430 billion of student debt relief? When? What, you think the HEROES Act did that? $430 billion. You think the HEROES Act said thou shalt forgive $430 billion of student debt on a whim? Okay, Congress authorized the forgiveness plan among many other actions. What has that got to do with anything? The secretary put it in place, and the president would have been accountable for its success or failure. But this court today decides that some 40 million Americans will not receive the benefits the plan provides because, so says the court, that assistance is too significant. With all respect, I dissent. So you dissent because people would benefit from the plan, even if the plan exceeds the mandate of the secretary under law. That's not an argument. What? Okay. Again, I'm no legal scholar. I'm no constitutional expert, but I read that and I try to put that in my head, which is even if I hadn't read the opinion in majority, if somebody said, you need to accept this plan because it would benefit a lot of people, I'd be like, whoa, wait a second. I mean, if an executive action is suddenly put into place that benefits a lot of people and doesn't end run around Congress and around the law, well, I'm just supposed to say, yes, that's good. It does good things for people. Then the powers that be should be able to do what they want. No. The executive tried to do an end run around congressional authority by quasi-empowering a secretary with the abilities far beyond their remand in order to fulfill a campaign promise. They've been talking about student loan forgiveness since before the pandemic. Biden made it part of his campaign. It had nothing to do initially with the pandemic. This, to my mind, and again, this is just my opinion from watching things, to my mind, the pandemic was an excuse to try to do an end run around the law and cite a bit of this HEROES Act as a mechanism to try to fulfill a campaign promise. And sloppily done, it seems like, because Kagan continually puts the word replace into this dissent, where the word replace was never part of the law. So I mean, if nothing else, I think the dissent, as a dissent, fails on that point alone. But anyway, that's just me. Let me go to the chat real quick and see if you guys have anything else to add, and then I will wrap this up, because I started out with a decision that is tangentially involved with this, but not the one inherently. Let's see. It's easy to fuck up when you're young, not sure what to do in life, and people are throwing money at you to choose something. Yeah, this is one of those lessons that you have to learn in life. Don't sign unless you've read what you're signing. And one of the oldest lessons of personal financial health: do not buy what you cannot afford. Obviously, taking out a loan for college is a roll of the dice, and you have to be strategic about it. If I'm going to take out a loan for several tens of thousands of dollars for an education, I should be thinking ahead of time, is the education I am attempting to pay for with this loan going to help me repay it? It's one thing to take out a loan. It's another thing to take out a loan for an education and going for a major or something that has either no or very little chance of easily recouping that investment. You know, if I pay tens of thousands of dollars for a college education into social justice, or feminist studies or something, I might be setting myself up for failure. But regardless, if you sign over yourself to an obligation like that, I'm sorry, you've put yourself in that obligation. That is your responsibility. You don't get a write-off for it, unless, as the majority opinion cited, unless somehow you were scammed or duped, or the other side of the contract was not fulfilled, or something else happened that was beyond your control and to your detriment. You are responsible for that loan. You signed the papers. You took on the burden. That was a choice you made. No one forced it on you. Let's see, renovation. But that would require questioning of the recipients, and they did not want to do that. Everyone knows a lot of it was spent on alcohol party. Okay, I was in the middle of a conversation I didn't know the beginning of. Big time. I believe trade school is a better model for schooling. To be an HVAC technician, there was nothing to learn about slavery. You're better off, I think, as far as, at least as far as having a backup. If you can go to a trade school and learn a trade, and thereafter at some point afford a higher education for something more specified, you're probably better off in the long run, both for your knowledge and your financial stability, because you'll always have something to fall back on, right? Dishwashers and grave diggers, always going to be a need. Accountants and technicians, always going to be a need. But anyway, let's see. Chauncey Stewart. Biden never promised to cancel $10,000 in student loans via executive order. No, I didn't say executive order. I'm saying that student loan forgiveness was part of his campaign promises. Now, I don't believe he ever said executive order, because he probably couldn't. I think he probably wanted to. I'm sure he probably explored the possibility. Biden said he would sign a bill if Congress passes a bill that would eliminate 10,000. Right. But Congress didn't. And instead, Biden was more than happy to try to do an end run around it through his secretary and use the pandemic as an excuse to still fulfill that promise. And again, that's just my theory, a political theory. And maybe I'm just being cynical and slightly conspiratorial, but that just seems to me like the most the easiest answer to why we have this in the first place. Just conveniently, of everything else that we did to the country during the course of the pandemic, locking everything down, shutting off businesses, destroying people's livelihoods, let's also throw them a little red meat with some student loan forgiveness that we can justify through an emergency. Even if that didn't technically make any sense, and certainly if it didn't fall within the powers of the secretary. But anyway, and then Tony Giff, be a plumber, electrician, bricklayer, no degree needed, and you learn on the job. Yeah, and there will always be a need for your services somewhere, because people still need water to run, the lights to go on, and walls to go up. Let's see. Anything else before I wrap this up? Oh, Brittany Holland. Hello, all. Starting from the beginning. Hello, Brittany. Future apologies for starting off with the wrong piece of decision, but was related to the decision that I eventually got to, because CNN fooled me. I thought this was the thing, or I clicked on the wrong deal, but whatever. It's all fixed out in the end. And we're all more knowledgeable for it. But anyway, everybody, I'm going to call it there. If I didn't get your comment, by all means, leave it in the comments below after the video is posted up. For those of you that donated, thank you so much for your generosity. I really do appreciate it. I don't have any other programming notes. I will be doing, presumably, a Sunday stream on, if you can believe it, Sunday at 8 a.m. Pacific, 11 a.m. Eastern. And then after that, I'm going to try to enjoy my 2-day vacation working Monday and then Tuesday off, because unfortunately I can't take Monday completely off. I have to work. But oh well, them's the breaks. For the rest of you, I hope that if you have the opportunity to have a 4-day weekend, enjoy it. If you just get Tuesday off, well, good for you on that one. If you can't get Tuesday off either, I'm sorry. But anyway, everybody, thank you for joining me. Leave a like on the way out if you would. I appreciate it. Moderators, thank you for keeping an eye on things. Even though everyone here is so well behaved, you have very little to do. Again, everybody, enjoy the rest of your Friday. Have a happy and safe 4th of July weekend. I hope you're otherwise all safe and well. If you are not well, please get well soon, and I'll see you on the next one. Take care. Bye-bye.